Crypto Twitter is awash with the rumor of SEC Chairman Gary Gensler resigning from the regulatory agency. Pro-XRP attorney John Deaton commented on the rumors, saying a Gensler resignation was possible. The SEC's AVs. Ripple Labs' court fight is one of the most high-profile cases, and as the industry awaits the decision, a lawyer anticipated the likely release date based on Judge Annalisa Torres' summary judgment ruling trend. Pro-Ripple lawyer Fred Rispoli said that the court's verdict in the continuing legal dispute between the Securities and Exchange Commission and the blockchain and software startup Ripple Labs might be released in August. The lawyer highlighted that 60 of the federal judge's rulings came between 146 and 330 days, with the judgment announced in an average time of 249 days. Using statistics related to the motion summary judgment of the United States District Court for the Southern District of New York Judge Annalisa Torres, who is handling the case. Based on these figures, the decision should have been issued on May 21, the 249th day after the original application for summary judgment was filed on September 17, 2022. However, it is no longer valid since that month has passed with no news from the court. Rispoli also hinted that the 330-day rule might be implemented in the SEC v. Ripple Labs case, and if that happens, the court's decision is expected on August 10 of this year. 60 of rulings are issued between 146 and 330 days, which is 249 days from September 17, 2022 to May 2023, and 330 days from September 17, 2020 to August 10, 2020, and 330 days from September 17, 2023. I may be getting the best birthday present of my entire life, the lawyer remarked, adding, peas, or the worst birthday present ever, either of those two. Rispoli's prognosis is a tad early in comparison to another pro-Ripple lawyer and crypto law creator John Deaton, who earlier projected using statistics that Judge Torres' decision may be issued on September 6. Deaton utilized Judge Torres' 6-month timescale finding on the Daubert motion in the Ripple Labs litigation on March 6, arriving at the September 6 date. She decided a case in which her summary judgment decision came 6 months after her Daubert decision. So if her Daubert ruling was made on March 6, it would be September 6 months later, Deaton said in a live video. Ripple Labs CEO Brad Garlinghouse has previously said that the continuing legal struggle is coming to a close and that the verdict might be issued in weeks. A pro-XRP attorney, John Deaton, addressed reports of Securities and Exchange Commission (SEC) Chairman Gary Gensler's departure. While reports of Gensler's retirement is only hearsay, Deaton thinks the SEC chair will leave for political reasons. SEC Chair Gary Gensler, according to John Deaton, an amicus or friend of the court in the SEC VVs. Ripple litigation. Deaton responded to a widely circulated claim on crypto Twitter about the agency chair's whereabouts. According to Deaton, the impending election campaign might result in Gensler resigning from the SEC after the agency's crackdown on Bitcoin exchanges and initiatives in the ecosystem. For nearly 2 years, the SEC has been involved in a legal struggle with Ripple. The banking authority recently sued Binance and Coinbase, two of the major exchanges in the cryptocurrency sector. The regulator designated almost 6 cryptocurrencies exchanged on their platforms as securities. In the case, implying that the exchanges were permitting the trading of unregistered securities, which is a significant infraction. Holders of XRP are awaiting a decision in the SEC CVs. Ripple lawsuit, according to Ripple Labs. According to Ripple Labs CEO Brad Garlinghouse, the summary judgment in the dispute will be issued by Judge Annalisa Torres by September. Pro-XRP lawyer Fred Rispoli predicts a decision in the SEC CVs. Ripple litigation by August 10. Rispoli derived this from Judge Torres' prior summary judgment data. At the time of writing on Monday, the cryptocurrency was trading over 4,810 cents. While XRP holders await the outcome of the lawsuit and Ripple's next actions, the cryptocurrency maintains its positive upward trajectory. as the cryptocurrency industry awaits the outcome of a lawsuit launched by the United States Securities and Exchange Commission, SEC, against Ripple. A pro-XRP legal expert has presented more reasons in favor of the blockchain firm's side of the legal fight. Indeed, in a tweet on July 2, lawyer Bill Morgan joined a discussion with well-known XRP community member Meister Huber and former SEC enforcement lawyer Mark Fagel, in which the former asked why the regulator filed no injunction at all if Ripple did anything nefarious or even illegal besides selling unregistered securities. What is the point of protecting investors if Ripple can continue to pursue what the SEC considers to be clearly illegal and damaging to investors for years after the lawsuit is filed? He said. Shouldn't the SEC have made an attempt to apply for this for the protection of investors? Furthermore, he said, the SEC would need to show how there is an investment contract when ODL customers who don't invest in the token and don't expect profits to transact the XRP within seconds for fast, cheap cross-border payments, not investments. Previously, Feinbold reported on Morgan sharing his thoughts on several seldom-spoken neighborhood concerns. Attorney John Deaton, the creator of CryptoLaw, took to Twitter to explain the significance of Judge Annalisa Torres' summary judgment ruling in the SEC vs. Ripple litigation. The comment was made by Attorney Deaton in response to a tweet by prominent Bitcoin YouTuber Scott Melker. Melker stated in a tweet today that if Americans do not fight back against the SEC's outrageous overreach, they would be limited to trading just 4 cryptocurrencies on Wall Street. Run exchanges: Bitcoin, BTC, Ethereum, Litecoin Cash, and Bitcoin Cash, BATE. Notably, Melker cited the 4 crypto assets since SEC Chair Gary Gensler earlier referred to them as commodities while referring to other tokens as securities. Furthermore, Melker said that the 4 digital currencies are the only ones traded on the X exchange, a recently formed crypto trading platform sponsored by Wall Street heavyweights such as Fidelity Digital Investments, Charles Schwab, and Citadel Securities. In response to the tweet, Attorney Deaton said that Judge Torres' judgment becomes potentially more relevant with each passing day. He said that if the court rules against XRP, it would be status quo, with greater political clout for those promoting anti-crypto campaigns such as Gensler, Warren Buffett, and Rep. Brad Sherman. Deaton, on the other hand, believes that if Judge Torres rules in favor of XRP, it would be good news for other crypto assets and the whole market. Meanwhile, the SEC has maintained authority over the whole cryptocurrency sector. According to Gensler, all crypto assets other than Bitcoin are securities, as previously reported. Following his statement, the SEC launched a broad investigation on cryptocurrency-related firms, saying that they violated securities laws. The SEC sued Coinbase and Binance last month with enabling the trade of unregistered securities such as ADA, Sol, Matic, and Algo. Remember that the SEC says XRP is a security, which brings the coin's secondary market transaction into question. Notably, Judge Torres is likely to make a decision on whether XRP secondary market transactions qualify as securities. If the court determines that XRP is not a security, it will set a legal precedent that calls the SEC's jurisdiction to regulate a large chunk of the market into question. As a result, other token issuers might use the judgment and claim that their particular crypto assets are not securities.